versus Bjork, and 11465 Commonwealth versus Refuse 5.
My apologies. Good morning, Your Honors. May it please the Court. Vincent DeMoore on behalf of the Commonwealth. We're here today asking this Court to vacate the lower court's orders allowing the defendant's motions to vacate their guilty pleas and enter a new order denying the defendant's motions. The cases before the Court today present fundamentally the same two issues. First is to negate the voluntariness of an otherwise constitutionally sufficient plea. Is it sufficient for a defendant to make a showing of generalized misconduct, or must the defendant demonstrate, as we suggest that he must, that there is a nexus between the misconduct and the defendant's case? Or put differently, that there was misconduct that occurred in his case. And secondly, presuming for the sake of argument that the newly discovered impeachment evidence surrounding the allegations of misconduct at the Hinton Laboratory constitute exculpatory evidence, do the holdings of Brady v. U.S., McMahon v. Richardson, Commonwealth v. Berrios, Parker v. North Carolina, and Tollett v. Henderson foreclose the defendant's claims to all non-jurisdictional defects to the complaint?
With respect to your second point, aren't you somewhat begging the question by describing it as, what did you say, impeachment evidence?
And I can clarify with respect to that, because in all of the briefs that have been submitted on behalf of the defendants, there seems to be this notion that the Commonwealth is suggesting that the evidence is not exculpatory. Impeachment evidence is exculpatory
No,
evidence.
but impeachment as opposed to impeachment plus. I mean,
I think there's a distinction between the two. I would characterize the evidence that we have here as impeachment, purely impeachment evidence. It goes to her veracity, it goes to her credibility, it goes to
it goes to more than that, doesn't it?
I disagree. What I would, if I could split the two into two different categories, just for the sake of the exercise, impeachment evidence, as we've defined it, and I think the Hathaway case is the case that really defines it best, goes to the judgment, the skill, the credibility, and the veracity of the witness. All of that evidence that we have here, all the newly discovered evidence we have here, does precisely that. Substantive exculpatory evidence, which is a term I'm making up just to distinguish the two, would be something that affirmatively negates the defendant's guilt. For instance, if, for instance, I'm alleged to have robbed a bank on Canal Street at 12:01 p.m., but the Commonwealth is in possession of a surveillance video from 12:01 p.m. showing me to be on Boylston Street, that's substantive exculpatory evidence that affirmatively negates the defendant's guilt.
But isn't there some evidence that that she contaminated some of the samples, and it could be that the substance in his particular case was a counterfeit substance. It was not a controlled substance at all, and yet she contaminated it with a known sample of contraband. So wouldn't that be substantive exculpatory evidence?
If it were true that there was a showing, or there was any evidence whatsoever that in the defendant's cases here today, that there was in fact some contamination which changed the results from from negative to positive, then yes, that would be substantive exculpatory evidence.
Given the lockdown, how would they show that before now?
Well, I'll say that the defendant's choice to proceed forward with incomplete information was the defendant's choice to proceed forward. But nonetheless, the Attorney General certainly was able to identify cases over that 18-month time period. There were a total of 12 where the results were changed from a negative to a positive. And in all of those cases, strike that, speaking only for Suffolk County, the 3 that were Suffolk County cases, we moved immediately to vacate those convictions because there's a showing of actual innocence. That's substantive exculpatory evidence that negates the defendant's guilt in those particular cases. So I do think there is a distinction between...
But are you saying that the ones that have already been identified are necessarily the only ones where the sample was contaminated with positive evidence and otherwise it would have been a negative?
What I'm saying is that those are the only cases thus far that we have any evidence that there was actual tampering in the defendant's cases. Those two, I'm not sure that answers the question.
Well, let me put it a different way.
Sure.
Were they identified because Ms. Dukin specifically said that those are the cases that it happened in?
No, a review of the documentation of the testing itself revealed some anomalies with respect to in essence, I'll try not to get too technical, but the allegations against Ms. Dukin are essentially as follows, that there would be some, what they call dry labbing, identifying the drugs by site. And then she would properly prepare the aliquot, which would go to the GCMS machine. And 98% of the time, because the counterfeit rate is somewhere around 2%, it would come back precisely as she had dry labbed it as. And the GCMS is a discriminatory test, pardon me. Occasionally, it would not. And we know of 12 instances in which it did not. And the procedure at the lab was it would go back to the primary chemist who would have an opportunity to make a new aliquot to run the machine. And there are some completely legitimate reasons why the machine may not give a positive result for positive drugs, which are, not, again, I don't want to get into the chemistry. And there's a record that shows that it went through twice. So the Attorney General's office pulled over that 18-month time period all the ones that went through twice. And of the 30-some-odd ones that they identified that went through twice, they were retested, and a dozen of those came back as negative as opposed to the positive that would have been expected based on the initial retesting.
And the 18 months was from?
January 2010 to her termination at the lab.
So are you saying that everything else is presumptively fine?
I'm saying that there's no evidence that it's not. Now, I can let the court know, with respect to the further review that's ongoing, is that the Inspector General is currently engaged in a review.
Do you know when he's, he said last spring that he hoped to have that by the end of the year. Do you know anything more recent than that?
My understanding, and this is from what I've been informed in the last couple of weeks, it's still expected that'll be done by the end of the year. But that review is reviewing every sample, not just Ms. Dukin's sample, but every sample that went through the lab from 2002 to 2012, the closing in August of 2012.
And do you disagree with the statistics that I've seen in these briefs that Annie Dugan did roughly 20 to 25% of all the testing?
I'm not sure in terms of the overall percentage. I simply haven't crunched the numbers with respect to that. But I will say that a lot of the numbers that have been thrown around both in the briefs and that you also, one may read in the media are not going to say taken out of context exactly, but certainly they're not placed in context.
You mean the more than twice as much as the next most productive, if I can use that word, chemist? Those are taken out of context?
Let's presume for a moment that's true, that her raw numbers were twice as large as the one before her. I would ask, what was she testing, and what was that chemist testing? For instance, the test for marijuana takes
year after year after year after year?
If I
It
may,
doesn't matter?
if the test for marijuana takes 50% of the time the test for heroin does. So if I was testing, as indeed she was for a few years, where she was almost exclusively doing marijuana samples in 2004, 2005, I think, her numbers ought to be twice as great. I'm not suggesting for a moment that Ms. Dugan didn't engage in misconduct, and I want to be clear on that. I think the allegations are powerful allegations, and ones that certainly we've taken very seriously. But yes.
I'm sorry to interrupt you, but a statement was made, not in this case, but in one of the other cases, Commonwealth versus Gardner, where on the record apparently the prosecutor said that the Commonwealth conceded that it was not able to prove with any certainty that Ms. Dugan had not tampered with the samples in the Gardner case. just for the sake of argument, if that statement were to apply equally to all the cases, why wouldn't it create a problem in all the cases?
Well, there's an issue.
The Commonwealth can't say that they weren't tampered with. How could a defendant possibly say they were?
Well, because I think there's a very big difference between proving the negative and proving that which occurred.
But they have no control over the, I mean, you can't hold them to exactly the same level, can you? The defendant and the government that's got control of all the samples?
When the court asks with respect to control of the samples, is that relative to retesting or the documents themselves?
Well, really, retesting is what I was referring to.
We would never oppose a motion to retest the drugs, and I can let.
Do they exist?
in-
Because like in one of these cases, there was a destruction order. I don't know if
And this is an instance where the failure of the Commonwealth, it appears to inure to our benefit, but the destruction order does not necessarily mean they were destroyed. I'd estimate somewhere around 95% of all the samples from 2005 onward still exist. But we would never oppose never oppose a motion to retest the drugs, and I can let the court know that not a single defendant in all the cases we've handled thus far, about 1,500 in Suffolk County, have requested retesting.
Of course not.
No.
But how do you, what does retesting do if you don't know if the samples were contaminated to begin with?
Well, I'll say we have no evidence that and I want to draw a distinction between the samples, as in the aliquot that's sent to the mass spec machine, and the
Correct.
evidence itself. There is no evidence that the evidence has ever been tampered with or tainted.
Wait a minute, wasn't it, she had access to lockers
She did.
where the evidence itself was kept?
The safe, yes.
And put in her own locker. So she absolutely had access to the evidence.
But that doesn't suggest that there was tampering with the evidence itself,
How do you know?
because there were negative retests. Those negative retests ought never to have
Of
occurred.
everything?
No. With respect to the ones that have been retested, they came back as negative, which strongly suggests, well, at the very least, there's no evidence that they were tampered with, but that strongly suggests that, in fact, there was no tampering with the primary evidence itself.
Do you agree that, wholly apart from, let's assume that the DA's office is entirely blameless here, and let's assume, because Ms. Dukin has not yet been tried, that there is misconduct that occurred at the public health facility. Do you agree that the Commonwealth is responsible for any misconduct that occurred in terms of it being imputed to the Commonwealth?
I think I would agree that Ms. Dugan, when she worked on the particular case, was a member of the prosecution team as we define that under our case law in Rule 14. So I would agree with that. But I would suggest that to impute her behavior in these cases, her ill behavior or the alleged ill behavior, to the government in these particular cases isn't necessarily appropriate. And what I mean by that is that when we talk about the prosecution team, we talk about those who are acting at the direction or the control of the prosecutor. So, for instance, if there is a lab report that we're simply unaware of, that's still in the government's care, custody, and control, because we have the ability with a phone call to determine whether or not that exists.
But weren't the prosecutors, in some respect, I'm not being accusatory by any means, but there certainly was a willingness on the part of both prosecutors and Dukin, at least according to the police reports, that if a particular prosecutor placed a call saying, "Hey, can you hurry up with my sample?" She would do that. She would be accommodating, and that may in fact have contributed to her her overzealous, and I use that term, I'm not being accusatory in any way, her overzealous attempt to do more work than was humanly possible.
Well, I think certainly we spoke with our witnesses. We speak with all of our witnesses. And I'd suggest there's really nothing inappropriate with the government speaking with its witnesses. But, I'm sorry. In answer to that question, the reason why Rule 14 discovery, or essentially why it's considered in our care, custody, and control, is it's subject to our compelled production. And again, this is a tertiary argument in the brief, but with respect to that unique question, the information here, the impeachment information, was contained solely inside of her mind. It's not like she was writing in her diary that she kept inside of her locker about all of her misdeeds. So to compel that production, she is still a citizen of the Commonwealth and does have her own Fifth Amendment privileges. So I'm not entirely sure we could have compelled her to testify against herself by making confessions. But even if one presumes for a moment that we had this information, that this information was entirely in our care, custody, and control, as a practical matter, of course, as we have done, we would turn that information over. But with respect to what the law requires on a change of plea or where there's a guilty plea, that guilty plea itself, under a long line of cases, both in the Commonwealth as well as at the United States Supreme Court level, indicates that that guilty plea represents a break in the chain of events, that it waives all non-jurisdictional defects to the complaint itself. In the same way that if there was, as in Parker v. North Carolina, confessions which were tortured out of defendants.
Well, let me ask you that. I mean, if a police officer plants drugs and a defendant pleads guilty to their possession, he can't withdraw the plea when it's discovered that the police officer planted drugs?
If a police officer has planted drugs on a defendant and that information comes to light, that is affirmative evidence that the defendant was in fact not guilty of the offense.
But the defendant admitted to his guilt, and maybe there was some dope. Maybe they just supplemented the amount.
With respect to
But
the
according to you, though, he's already admitted to his guilt. So
it's a guilty plea, and I want to be clear on this, a guilty plea is not a cure-all. It does not, if a defendant pleads guilty and there is information of their affirmative actual innocence, the defendant is not out of luck.
So no matter how terrible the conduct is, as long as it doesn't actually go to actual innocence, it doesn't matter? We don't care about the integrity of the criminal justice system?
No. If the conduct has a bearing on the defendant's voluntariness, the voluntariness of the defendant's plea, then yes, it does. United States, or pardon me, Ferrara v. U.S., I think is the controlling case with respect to that, where there's egregious governmental misconduct that antedates the entry of the defendant's plea, which essentially induces the defendant's plea, and it's material to the defendant's plea, that negates voluntariness. Newly discovered evidence, I would suggest, always goes to voluntariness or knowledge when
you
we're
say
talking
it's
about
newly discovered, but you also, I think, it conceded that her conduct can be imputed to the government. So what she did is what the government, albeit not the prosecutor, had knowledge of at the time of the plea.
Well, and I see my time is up, and I'll be back in about 15 minutes. But with respect to that, I wouldn't say that we're conceding that the conduct can be imputed to the government, because as I said, the information, the impeachment information here, or the evidence in this case, or in these cases, is contained solely within her mind, and we cannot compel its production.
That's a case with a detective too who plants evidence. It's solely in his mind.
Yes, and under Campidi, Waters, and Ellis, in all of those cases, particularly in Waters, the court talks about when a witness engages in their own unlawful conduct, essentially they absent themselves from the prosecution team. But I see my time is up, and with respect to these matters, at least I'd rest on the brief.
Welcome back, Mr. Warren.
I fear you might be getting tired of me. I beg the Chief Justice's indulgence for a minute before we start, before I start my 7.5 minutes, just administratively.
Stop the clock.
Thank you, thank you. The clerk asked us to get together and try to avoid repetition, and we've done our best to do that.
Hold on, I just don't think that's on. Is it on?
It's stopped, it's paused.
It's paused.
Oh, you want it to be paused?
I want
That's
it to be
right.
paused.
Sorry,
That's right. Thank you.
Okay.
The Chief Justice has granted my request. So there are 6 defendants here today in various stages of having motions granted, not granted, different things about our cases. I'm splitting time with Rakeem Scott's counsel, 7.5 minutes for myself, 7.5 minutes for Attorney Belger, and then we've got 2 other cases that are grouped, and then we've got 2 other cases that are each separate. We've gotten together, we've tried very hard to avoid repetition, so we're each going to be dealing with separate things. We've tried our best to predict why you've grouped the cases the way you've grouped them. We think we have some ideas, and we're hoping that different people will be talking about different things. So there may be times where I will try to pass the buck, and it's because I know that I've already, if it's a topic we've already talked about, I'm going to be leaving that to my colleagues. So with that, Your Honors,
All right.
Thank you very
Back
much.
on the record now.
Thank you. In this case, at least, the most important thing I think for this court to understand is that Annie Dukin was the primary chemist. She took custody of the substances in question, meaning she took them out of the drug locker. She had sole custody of all of the alleged drugs in her personal possession. She put them in her drug locker. She was the only person responsible for those drugs. The district court granted the defendant's motion for a new trial. Rule 30B provides the trial judge may grant a new trial at any time if it appears that justice may not have been done. All we have to prove is that the district court did not abuse his discretion in finding that, in light of Annie Dukin's massive misconduct, admitted that justice in Mr. Bjork's case may not have been done, a very low standard.
Let me just ask you this, though. Certainly the judge made no findings at all, and I don't believe, but you could correct me if I'm wrong, that your client didn't submitted an affidavit.
Those are both correct, Your Honor. So
how do you operate a system where you don't have findings on it, you don't have an affidavit and you don't have findings?
I completely understand. First, I would just say that I wasn't the attorney below. I will say this, that, first of all, trial counsel tried, actually, and if you go back, and this is in the record, if you look at the transcript of the new trial motion, counsel tried to actually introduce the Dukin records. He, in fact, had issued a subpoena to Trooper Irwin, who was in charge of the investigation, to authenticate the documents. He intended to bring Trooper in to authenticate the documents and introduce them. In fact, the judge below, you'll see this, denied a motion to subpoena him, bring him in, and then before counsel had an opportunity to introduce the records, said, I'm just going to grant the motion for new trial. Now,
How about the affidavit question from
Right.
your client? Because, I
Right.
mean, if you're trying to withdraw a guilty plea, assume all the bad stuff. It's got to make a difference to him, right?
I agree that it would have made this court's job much easier to have that, absolutely. And I think in this is the early days of this litigation. In the newest generation, the guidance is absolutely due, as Your Honor suggests. But we're here.
But let me just follow up on that, follow up on that point. There's a distinct flavor that's created by the absence of a defendant's affidavit that suggests I'm not really. I knew that I had drugs, notwithstanding the absence or the problems with the Dukin certificates. I mean, how do we deal with that?
Well, okay. I mean, the way you can deal with it, I don't want to go beyond the record, so it's a little hard for me to answer that. Actually, I have a great answer for it. So first of all, the large question, the larger issue is, or doctrine is judicial notice. What we would really say is, and I've addressed this in my brief, at pages 20 to 23, the red brief, that there's a great case for judicial notice here. A court may take judicial notice of a fact so long as it is not subject to reasonable dispute, in that either it is, one, generally known within the territorial jurisdiction of the trial court, or two, capable of accurate and ready determination by resort to resources whose accuracy cannot reasonably be questioned. So that comes from, the Mass Guide to Evidence lays out the test. And Nantucket v. Beinecke, which Mr. Torres's counsel has cited, this court may take judicial notice of facts that are uncontested and indisputably true. So the first part, I understand this doesn't totally answer your question, I'm going to get to the second part, is what do we know? What we're saying is the fact that there was an investigation is appropriate subject of judicial notice. The fact that all of the documents that the Commonwealth introduced in its application for direct appellate review are appropriate topics for judicial notice. I'm not suggesting that the truth of the allegations, that's not necessary to support the new trial motion at this point. It's merely that the fact that there was an investigation, okay, and that Annie Dukin said these things, not the truth. Now, with regard to your second question, the flavor of this lack of an affidavit, absolutely we disagree with that. The reality here, and this is why it's a little hard to talk about things that are not in the record, the reality here is that what was going on in these early days was defense lawyers didn't know how to proceed. They didn't know exactly what to do.
One of them did. And again, I think it was
Sure.
the Gardner case.
Right.
One of the lawyer, I think, submitted an affidavit saying that if I had known this stuff, I would have told him not to plead guilty. So, I mean,
Right.
it's the flip
There's
side.
always a spectrum, and I absolutely agree. In this case, it was an unfortunate oversight not to include an affidavit from the defendant. I absolutely deny or reject the flavor that the defendant therefore knew something. Here's why. The facts
No,
of
not that
this
he knew
case.
something. I think what Justice Fina was saying was the flavor is that he knew he had drugs.
Okay, that he knew, what I mean is he knew that they were drugs. The flavor that, I understand what you're saying. The flavor that the defendant knew these were drugs, and so therefore he can't sign an affidavit. Absolutely not supported by the record, in my case. Why do I say that? The facts are, and they are established in the police reports, which are part of the record. Very simple, straightforward fact pattern. The two cops are out on the beat, and they see what looks to be a transaction for illegal substances. They immediately stop both parties. They find in my client's possession the substances. They find in the other fellow's possession the money. And, well, actually, they don't. They see him throw it into the garbage, into the drain, and then they pick it up. And then, so it's clear. It's absolutely clear what has happened. Corey Bjork has just bought what he thinks are illegal drugs from this other fellow, and the cops have immediately seized them. In that scenario, it's clear that Mr. Bjork has no idea what the substance is. Is it a fair inference that he thought he was buying illegal controlled substances? Yes, that's a fair inference. I'm not hiding from that. That's not enough to prove their case. If he bought counterfeit substances, and in the underworld of illegal substances, that's not a crazy proposition. People sell fraudulent material all the time. And Nazatal, this court knows these things. I'm not telling you anything you don't know.
But why didn't he file an affidavit saying, I didn't know what I bought?
Well, he should have. I absolutely agree. But you can't draw any other inference from this than what I just laid out. There is no reasonable inference that he did, in fact, know what he had bought. There's no way you can infer he knew what he bought from the fact pattern I just laid out. Because he had just received the material, and it was immediately taken from him. If you've got a different fact pattern where I don't know, that they see him use the substance, and then you could infer maybe that therefore he knows it's what it's supposed to be. But here, there's no way you can infer that.
But he wanted to buy controlled substance, at least arguably, inferably. And couldn't he have said in an affidavit that I didn't know what I bought? I was hoping to buy something, but I had no way of knowing that what I just got from somebody was a controlled substance.
He absolutely could have done that, but that would not have, it's not at all necessary in this situation because of that. But I know my time's up. I wanted to at least say one thing, which is the Commonwealth's last statement was Ferrara. They finally got to Ferrara. I beg this court, and I'm sure Ms. Belger will carry on this point, to ask how this is not egregious government misconduct under Ferrara. It seemed they ignored it completely. In this case,
you have evidence that there was misconduct in this case. Other than there was misconduct somewhere in her 8-year history of the
I want to answer this. I just don't want Ms. Belger to be penalized. She should get her full 7.5 minutes.
But you started this. Go ahead.
Egregious government misconduct by Ms. by Ms. Dukin. It's absolutely egregious government misconduct. The fact that she has admitted to engaging in this misconduct, period, in the line of her job, is enough to undermine at least every case where she is the custodial chemist, in other words, the primary chemist, takes complete custody of the substance, and there is no basis to prove that that this was the defendant knew these were narcotics. In my fact pattern, I satisfy both of those. She's the primary chemist, and notwithstanding Justice Spina's argument, I submit there is no way you can.
I didn't argue.
Sorry, right. Sorry, I apologize. Interesting hypothetical. There's no way to infer that Mr. Bjork could have known these were controlled substances. Thank you.
Thank you.
Good morning, Your Honors. Amy Belger for Mr. Scott. Mr. Scott has the strongest case, actually, before you of all these Duke and Lab cases. And the reason is because the questions that you asked to my co-counsel in the last case are answered much more favorably in Mr. Scott's situation, on his fact pattern.
You're making enemies for yourself among your co-counsel?
I have one client, Your Honor. I understand it's a big scandal, it's a huge debacle, it's a public disgrace. I have one client.
I understand.
He was in a housing project. They found out he had a warrant. They took him into the station. They pulled something out of his pocket, and that was the end of it. They sent it to the lab, and Annie Dukin claims that it was cocaine. There were no statements. There was no indicia of engaging in drug activity. He had nothing on him. He said nothing.
Did he file an affidavit?
He did not provide an affidavit, Your Honor, and it would be nice if he had provided an affidavit. However, there is nothing in the text of Rule 30 or any case that's ever come down in this Commonwealth that has said a judge cannot grant a motion for a new trial or to withdraw a plea on behalf of a defendant who doesn't provide his own affidavit.
But don't you have to show, doesn't there have to be some evidence that it made a difference in this case? And where's the evidence that it made a difference in this case?
I mean, to him.
To him.
By virtue of the fact that the motion was brought, there are scores of defendants where Annie Dukin tested their drugs who didn't bring motions to withdraw their pleas and who didn't bring motions for new trials. By virtue of the fact a lawyer comes before the court who doesn't do anything other than what their client wants them to do under ethical rules and says, I want my plea back now that I know that this woman was contaminating evidence at the lab because I don't know what was in my pocket. That's basically what he's saying. And he has his attorney do that because he doesn't speak for himself. That's the voice through which he does that.
Now, I think it was your brief which said that there must be two findings made in order for a plea to be properly withdrawn. One is that there was egregious government conduct before the plea, and secondly, that the misconduct was material to the decision to plead guilty. That's in your brief.
It is.
Okay. And how do we, without an affidavit, how can a judge, are you saying that merely because the attorney brought the motion, that is sufficient to establish the second element?
Well, the attorney's affidavit certainly says that it was material because if it was known that the Commonwealth could not establish a required element of guilt, that would have affected.
Okay, and is there one here?
Yes,
Okay, which
there
says
is.
basically,
Yes.
if I had known what I know now, I would never have had my guy plead guilty.
It is not that clear.
Okay.
It says the Commonwealth has committed a Brady violation. The evidence was exculpatory. If we had known about this exculpatory evidence at the time, then yes, and that's why. And the other thing too, Your Honor.
We had known, I would have advised him not to plead guilty. Is that the rest of that sentence?
If you look at the transcripts on the hearings, there were 2 hearings in Mr. Scott's case, neither of which the Commonwealth told you about, where this was discussed extensively by the judge who had to decide this motion on exactly that. The judge says to the prosecutor, well, don't you think if Rakeem Scott knew about Annie Dukin, don't you think that would have affected his decision to plead guilty? And the prosecutor says, oh, yeah, I definitely think it would have. And the judge says, well, geez, she's under indictment. There's all this evidence of wrongdoing, and you're agreeing with me, Commonwealth, that would have been a big factor for him. The Commonwealth conceded materiality in this particular case. So the fact that Rakeem Scott didn't put an affidavit in the motion papers along with counsel is easily dispensed with that way, because the judge, before granting this motion, fully examined whether or not this would have been material to Mr. Scott, and that's why he held 2 hearings on it. Now, with respect to
Now, even if you're right, do we not need to send it back to the judge for findings as to why he did what he did?
I think that, Your Honor, he makes a record where he notes that Annie Dukin is under indictment, that there's a widespread investigation alleging misconduct and falsification of records and tampering with evidence and wrongdoing. He asks the Commonwealth whether they think it would have been material. They say yes. He didn't write a written decision, but it is very clear. All the record has to show is that there is a reason for him to grant the motion.
So you're saying it's implicit?
It most certainly is, Your Honor. All you have to do is have a reason. All he has to do is have a reason. It would be wonderful if all these district court trial judges in every single case gave a beautiful written decision telling us why they do what they do. They don't.
They could do it, they could do it orally.
If anything, if they just give us anything.
So in the
It
other,
doesn't.
so, but if one accepts that, what about one of these cases, the judge came to the opposite conclusion? Facts are different, no reasoning. Is that okay too?
I think that, and considering what we're talking about here with these Dukin cases, and many of us have advocated that you need to sort of, in the interest of justice and fairness and looking at the magnitude of this scandal, that you do have to sort of put some equity to the entire situation and come up with a far-reaching sort of global solution. But it is certainly a fair question, and it's certainly something I think that factors into what action, if any, you believe you have to take as a court in light of the Hinton drug lab scandal. But, you know, I would say that Rakeem Scott should not be penalized because the judge did not take the time to write down what he said on the record as to why he was granting this motion. That's very clear from the transcripts and are sound legal reasons and certainly satisfy Rule 30 as to why he was granting Rakeem Scott's motion. Rakeem certainly shouldn't be punished because the judge didn't put in writing what those reasons were that are on the transcripts. But certainly all the other defendants that have been affected by this woman's misconduct, again, they come here seeking justice and fairness. And in terms of the technicalities, you are absolutely right. The Commonwealth is absolutely right. It would be absolutely wonderful, beautiful. None of us would be here if these things had been done, you know, technically according to the way procedures ideally should be done. They weren't. These people are still entitled to justice. Their liberty that they were deprived of because of this woman's behavior is a far worse scandal than anything having to do with procedures that may have been rushed through at the district court level, trying to get them the relief that they're entitled to.
All right, thank you, Counselor.